I'm saying what brought that initial application. That has come up later. I'm asking the first one that brought up the issue. That is what I'm concerned with.
Yes, my lord.
That ruling has just come now, 1 hour ago.
Precisely, my lord. The issue is designed as stands on record.
You made the application at night around 10 o'clock. So the issue, so that's what it goes on record, and I get it very clearly. It is the issue of the issuance of the conservative orders, despite there being a contestation of the question of jurisdiction.
Precisely, my lord. And other grounds to be supplied by our client, the basis of the factual grounds, the basis of which will form the basis of our application.
So that now the issue of the court order is not disputed.
No, my lord,
as counts on record, my lord, we are aware of the court order. As counts on record, we are aware of the court order. We are aware of the irregularity, and we presuppose that is one of the grounds for application for recusal. We cannot submit as counts on record on behalf of our clients without the instructions. I can't stand here, my lord, and say our client has unless they file an application.
I just want you to go on the record correctly, so that in the event this matter ends elsewhere, it is clear what you are saying. Okay?
Yes, my lord.
My lord, may I? 5 seconds.
I thought you said enough, Mr. Mbaye. Now the other parties will also ask for a chance to respond.
We are on the floor,
Mr. Host, my lord.
Yes?
We are on the floor, my lord.
Yes.
My lord, I was just going to say this, just very briefly. The question you are asking is, and this is the concern with our client and us as lawyers, as officers of the court, that the failure to determine the question of jurisdiction, then for the court to go ahead and summon our clients, that is the whole question of bias. Why will the court ignore a substantive issue of jurisdiction, then go ahead to summon? That's why the clients are saying that this court is biased. They have not determined a fundamental question of whether it was jurisdiction or not to handle this matter. So as counsels, we are aware of the order. But when you ask the client, and the client said, no, but this is wrong. We instructed you to raise the question of jurisdiction of this court. This court has ignored that and went ahead to summon them. So, my lord, what we are saying is, as a balance, in the interest of fairness, a lot of articles have been settled of the Constitution. In the interest of fairness, give us time to seek instructions. In the meantime, stay these proceedings, allow us to appeal. If you want to go by way of your earlier ruling, then we want to appeal this ruling of yours of this morning, because that question of whether you are competent to give the orders or not is in question. It's a question of law.
Dr. Now, I'll come back to you now and answer the question again.
Yes, my lord.
Because from what I gather now, it is your finding that from your client's instructions are that now these orders for the court were issued before the issue of jurisdiction was determined. So if I get it correctly, is that they say that means they are aware of the orders.
My lord, as we have said, let
us not agree, Dr. You cannot be agreeing by an order which you are not aware of. So they are aware of the orders. Irrespective of whether it was issued by a court with bias, a court without jurisdiction, all that. They are aware of the orders. Let me go on record for that.
My lord, we informed them today that we have seen an order that barred you from proceeding. I have not seen the county assembly proceedings. I don't know the details myself. And this is why we are asking you to be fair to us and to everybody. Give us time. If you want us to put in a formal application, we would be more than happy to put a formal application where we can confirm the question that you asked us earlier. You've been asking us. But in the meantime,
Are you
Our clients
aware,
are-
Dr. Court, I know you've come very late, eh?
Yes.
You've come a bit late in the matter, but you are aware that they were here on the day.
My Lord, I think we have an issue with the
No, I
court's
just want-
mind.
No, I just want, you see, the only issue I have myself right now, Council, are two issues: content and jurisdiction. Now you've introduced another one for recusal. That's the only things I'm addressing, nothing else.
My Lord,
Yeah, so-
we also have the
And I
question
have
of
not,
stay.
and now stay for that. And the last time you came here, I told the parties you only addressed me on the issue of content and jurisdiction.
So my Lord, what we've been submitting
Now
all along.
another issue now has been raised, the issue of recusal and another issue of stay. So the question is, and so that it goes on record, your client's grievance is with the order that was issued on 25th, is it 25th of June?
Yes, my Lord.
So that is the position.
Sorry, Your Lordship.
Your clients are aware of the orders from your submission.
Your Lordship, I am an officer of the court. I have a duty of candor to you. And Your Lordship, I have not taken instructions on that.
No,
so I mean,
it is the basis of that they're asking the court to recuse itself. So they are aware of those orders. It's those orders that they are asking themselves, the court to recuse itself.
Your Lordship, I have not taken instructions. However, I am just relying on the record as is.
So what is the basis of the application for recusal? Because I want it to go on record.
Your Lordship, I have mentioned bias.
By
on
which
the basis of the various reasons that.
Which order?
Sorry?
Which order?
But my Lord, may I, with permission, counsel, may I step in there?
No, I'm asking Mr. Wafula.
Yes, Your Lordship.
We are
Which
in the
order?
same team, my Lord.
Yes, which order are they aggrieved by?
Your Lordship, I have mentioned various.
My Lord, if I may offer clarification to the court.
Now, I'm asking Mr. Wafula first. If you don't know, then we just say you don't know.
My Lord, I do not. Let my learned friend.
All right. All right. That's the next question I'm going to ask you, Mr. Wafula. If a party is aware of a court order, despite contestation of jurisdiction, what are you supposed to do?
Sorry, Your Lordship.
If you are aware of a court order, okay?
Yes, Your Lordship.
You feel that the court is biased, should not have given the order. What is the correct position in law?
Your Lordship, it is to appeal that particular order.
To appeal.
Or review or set it aside.
Okay.
And Your Lordship, it is this particular question, Your Lordship, that further compounds our client's fears, that the court's mind is made up.
All right. So, Mr. Bayer, you're saying
Yes,
something. Are you answering that question?
Yes.
Are you answering that question? Yes.
Yes. Can you hear me? Can the court hear me, my Lord?
I can hear you, Mr. Bayer.
Yes. My Lord, we have dwelt on this issue since morning. The answer to your question is clear. Our clients have not had an opportunity to put in a response whether or not they received the court order, but we are assuming that because of the court order, the same ought to have been served upon our clients, and our clients have in their possession that order, and they know its contents. We do not have clear instructions,
so
we do not have an affidavit on record from our client saying that they have received that order and they complied with it or not. That's a matter which our client must respond to.
So what are they aggrieved by? Because the first time they came and said they wish to apply for recusal. What order aggrieved them?
My Lord, as we submitted before you in the morning, Our clients have given us
I'm asking
instructions.
you,
Yes, my lord.
which order has agreed with them? So tell me it is the order of this day so that it goes on record, council. Just say, tell me it is the order of this, that order. That's what it
My
goes on
lord,
record.
as we have submitted before, my lord,
Yes.
we don't have clear instructions as to the content of our client's application for execution. But as comes on record, we know it is irregular for court to give a conservatory order when a motion for jurisdiction is pending. So it goes without saying that one of the grounds in the application ought to be the conservatory order issued by the court, my lord.
Right to hear.
Our client will give us further instructions as to the contents of the application for recusal.
Fundamental right. Well,
But as now, there is a legal issue which counsel on record can discern on the issue of conservatory order before the question is.
Just maybe to disable the mic for the person who is there.
My lord, there's a lot of background noise.
Disable the mic. And remove from the meeting. In fact, you come here, remove from the meeting. They continue studying. It's okay. Please, the next person who interrupts now will be removed from the meeting.
My lord, may I address you after Mbaya?
My lord, can you hear me? Yes, my lord.
If I get what you're saying, so it goes on record.
Yes, my lord.
Part of the complaint by your clients is that the orders of stay issued.
Yes, my lord. Yes, my lord.
Okay.
When an application when an issue of jurisdiction was pending before the honorable court, that issue of jurisdiction ought to have been dispensed with first before the court could give an order of conservatory order, my lord.
So by extension, it means they are aware that the order of stay was given.
Yes, my lord, those are instructions
I'm saying, from that argument, it means they are aware of the order. You know, you have been recorded, Mr. Bayer.
Definitely, my lord.
Yes?
Yes, my lord.
They are aware of the orders.
Yes, my lord.
Okay. Tuafula?
Yes, my lord, I would only associate myself with the submission.
Please remember, it's just a rejoinder.
Yes.
Don't raise new issues.
Indeed, your lordship will not raise any issues.